Do you hear me? Okay. My name is George Krimlis. I'm a head of unit in DG Environment responsible for environmental impact assessments. So the point I wanted to make is that this is a Seveso type directive or regulation that was tailored to the offshore needs, which means that all the other pieces of environmental legislation that are applicable will have to apply in addition to that. This is for PAL. A point I wanted to make, namely the Marine Framework Directive, the Natura 2000 Directive, when it comes to the marine Natura 2000 sites, and it would be interesting to visit the new viewer of Natura 2000, which is on the internet, where you can also identify the marine Natura 2000 sites, at least those that have already been identified, where this type of investments could take place, hopefully not within the Natura 2000, but next or not far, and could possibly affect. So there are a lot of other safeguards and guarantees that the environmental acquis, which is mostly directives driven, will apply. Now, I'm very much tempted not...
Having a question rule, so if you don't have a question...
let me turn it to a question if you want, but I wanted to say the following thing. There are regulations with directive-type provisions and directives with regulation-type provisions. So at the end of the day, it depends how you shape the provisions. And the direct applicability has been acknowledged by the court, even for directives that are drafted in a way that are directly applicable. So at the end of the day, the type of the instrument is not so important. What is more important is that our experience with the directives in the field of the environment is that you need 2 years to transpose them. And I can tell you that all the member states are late. 5, 6, 7 years. We launch infringement procedures, we have court judgments, things do not change. So the level playing field is extremely important. And I was really impressed by what the UK was telling, because I always remember that in the groups in the council, the UK was pleading in favor of the level playing field, telling us that this is extremely important. And there is here an additional argument. The level playing field is important not only for competition and even application purposes, but also because if you have an oil spill or an accident, as the ones we saw in the pictures of PAL, you will have a pollution that will travel across the EU and which can affect also third countries. So in that respect, it is important to ensure that not only our own member states will comply, but also the third countries. Okay.
Okay, can I ask okay, if you pass to the gentleman behind. Thank you.
Okay, thank you. Steffen Weber, Secretary General of the EU Arctic Forum. I'd like to... Okay, now, I'd like to highlight... Sorry, excuse me, coming from the Arctic. Indeed. I'd like to highlight the fact and connected with a question. The Arctic is, unlike the Baltic, not in EU jurisdiction. So when I see amendments by certain MEPs asking for member states not to issue licenses, I wonder what member states are they talking about? Have I missed something? Is Finland getting back its border with the Arctic, or has Russia joined? So what we need to have in mind is it's a special situation. In that regard, a question to Paul. There's a debate in Norway whether this EU legislation, regulation or directive will be applicable through the EEA agreement. That, I think, is an important issue. Second, the Arctic is always referred to, almost always referred to, as one. That is not correct. We must have in mind, while Stockman was closed down, at least laid on ice now for difficult conditions and high investments and technology difficulties, there is in other places in the Arctic, so to say, an upstepping. We see the Barents Sea, totally ice-free all year round, shallow, close to the land where operations are in place. And there is a second factor, I'm almost done, there's technology development. In the Barents, we have in operation the Snøhvit field, which is a subseabed installation. So that requires a special, so to say, attention, I believe, in this regulation. Thank Thank you.
Okay. Then last question here in the blue shirt.
Thank you, Mark. Mark Johnston from WWF in Brussels. Why is this piece of draft environmental protection law being considered in the Industry Committee in Parliament and among energy ministers? And why was it prepared by the Energy Department when it is clearly a piece of environmental protection law? Mr. Bellet, in your initial contribution, you spoke about, at the national level, the need to keep clearly separate the different responsibilities of public authorities. Should that also apply at the European level, please?
Thank you for the very succinct and pointed question. Paul, if you come in on the EEA question, that's very interesting.
Yeah, the EEA question. Now, as you all know, Norway is not a member of the EU, and usually I'm quite a convinced advocate that it should be. But in this particular case, I'm probably not so convinced. We have as Mark pointed out, the energy legality of this. We have in Norway a Minister of Petroleum and Energy who recently said that we want to drill all the way to the North Pole. And so we believe that there is a strong need for a specific Arctic regulation on this. Now, why is the Norwegian Foreign Minister and the Petroleum Minister so adamant about keeping this legislative initiative out of the EU? I'm pretty confident that they will not succeed because it is built on a range of a key which is already fully embedded in the EEA, so the European Economic Area, for those who are not familiar with that. But nevertheless, why do you think it's so important? And why have they been so vocal about it? So I think that it's probably not the reasons that the petroleum industry fares this to such a large extent, because they are fairly advanced compared to many other countries' petroleum industry. But I do believe that it is a clear political issue behind it. It's because this can set an important precedent that the EU legislation will be applicable to the economic zone of Norway, which has recently been given to Norway all the way to the north of the Svalbard Peninsula. And that is the big, that is a big issue. Who has the right to give licenses and collect taxes for drilling for petroleum in that region? I hope we shall be able to prevent that. But in the event that they should start drilling there, that is why Norway is quite desperate, in fact, at least this government, for keeping the directive outside the EU. Now, just very briefly, Stefan, I think that you have an important point about the inability of the EU to legislate in this. But we see a whole range of legislation that has extraterritorial application. We see an ETS, we see a commissioner for climate action, which is very ambitious. And by using the collective economic and political weight of the EU to enforce legislation in other regions, I think there's something to be learned from that could be included in a legislation in this particular area.
Maybe to Ivo or maybe to Jan about why it's the Industry Committee, Energy Ministers and DG Energy.
Yeah, why it's Commissioner Oettinger that Jan can answer why it's in his portfolio, of course. Why it is in the Industry and Energy Committee, it is not solely within the Industry and Energy Committee. I'm the central rapporteur within the Parliament because someone has to do it, so it's me. But a lot of articles of this proposal are of the exclusive competence of the ENVI Committee, of the Environment Committee. Other articles are of the exclusive competence of the Legal Affairs Committee, and other articles are of joint competence of Jury and ENVI, or Industry and ENVI. So it's a joint competence within the Parliament, and that's the difficult route that we have chosen. It's I think Article 50 within the regulation of the within the the regulation of the Parliament. Sorry. The rules of procedure of the Parliament. Sorry. Yeah. So that means that we have a joint responsibility within the Parliament. Yeah.
Okay, Jan. Want to explain why it's been keeping you so busy?
Because it's fun. Well, I obviously I can't answer for my top boss, but I can respond to Mark that it is not a piece of environmental legislation. It is a lot more than that. You could, of course, it's been initiated by a very serious environmental disaster in the Gulf of Mexico, and the lessons we draw from that and implications for European industry. But remember that in the Gulf of Mexico, it was not only the millions of barrels of oil, it was also 11 lives that were lost. It was also a major company, coincidentally European, that was on the brink of collapse because of the reaction of the markets, and it is still saddled with enormous financial obligations. It was an enormous impact on the economic life in the Gulf and on the communities, coastal communities, their well-being, their maritime activities, etc. It is a lot more than in environmental law. As much as, of course, one of the key goals is to ensure that we have proper rules for handling environmental impacts from offshore activities. But I think there is, as I said, there was a lot more to it in the Gulf, and we need to cover a lot more also for the EU in this.
Okay.
Could I make a comment on that?
Steve, just quickly, yeah.
The other thing that interests me is that there seems to be this homing in on the Arctic as a special case. The thing that myself as an engineer, I can't understand why the Arctic is any particularly more sensitive than any other area. I've drilled west of Shetland, and see some of these photographs down here. There is an enormous amount of wildlife out there. In the middle of the Mediterranean, can you imagine what would happen if we had a spill in there? The Arctic is not a special case. We shouldn't be looking at it as just a spill would be as much a disaster in any other area than it would be in the Arctic. I don't think it should be singled out as a special case.
No, but the response, the intervention is...
Yeah, that's important.
Because, Stephen, from a purely professional point of view, I hear you and I understand you, but I think that you also need to consider, I hope you would need to consider, the particular fragile ecosystem that is there, that is so much more exposed and so much more vulnerable to any accidents. Now, I'm very glad that you are traveling around the world to increase the standards globally. But we do see some very prominent oil companies that are actually being very frank and very honest and say that, it's not the same to meet the challenges of the oil industry in this region that in the other ones. And again, yesterday there was a lot of press about what happened when the hurricane just hit the Gulf of Mexico. So what it did was that it stirred up over 1 million gallons of crude oil that was lying on the seabed, and that now they have to impose an embargo on industrial fishing in this area before they've been able to clean it up. And we are now a couple of years ahead. So obviously, if it can create such threat to the ecosystem and the fishing industry in the Gulf of Mexico, I think we have a much more important problem in the very fragile region of the Arctic.
Yes,
My point is
very quickly,
we need to
wrap up
on the emphasis of preventing any spill. That's where we should be putting our efforts, not in dealing with it afterwards. All of this is after the event. We should be stopping it before it happens. There is so much we can do there.
Okay, thanks. I'm quite keen to finish on time, so if you have one very brief question that can be answered very briefly, I'll let you. But if I hear a statement developing, I will cut you off.
Don't worry, I'll put it in the question. Isn't it technology that will decide whether the Arctic is special or not? The buzzword subsea bed installations under the sea, or icing and tough weather conditions above.
Quick answers along the panel, and then we'll.
We can do yes and no on that.
Yeah.
Yes,
Steve?
yes. You can develop technology to do almost anything. Go to the moon, drill under the Arctic. That's all. But if the people are not competent, if the people are not trained, you're going to have the same event. That's where you should be putting the effort. That's my thoughts.
Okay. Jan?
The legislation is designed as goal setting and therefore obliging the operator to take all necessary measures commensurate with the risk that have been identified. This is one of the guiding principles. We believe it's the right one. We agree on. I hope the industry agrees with us on that, and that's the solution in a way.
Okay, Ivo. And then
yeah,
Paul.
we've introduced the idea, the principle of an oil spill response gap in our proposal amendment. I think that we all agree that the Arctic is much more extreme weather conditions, and that we have it is reflected in the initial proposal of the Commission. You have to take into account the degree of the risk. So it is already in the initial proposal of the Commission that the extreme circumstances. Yeah.
Okay, Paul, I think I can guess what you're going to say, so you only get a one-word answer.
Well, the answer is no, because we know that the only thing that we can be sure is that the unexpected can happen, and we cannot. Technology will evolve, absolutely, and we're very much in favor of that. But we can never exclude that there will be a human error, and as Ivo said, due to the specific circumstances. The risk aspect is all the more important in this area. So the answer is no.
Okay, thanks. Alex Trott from Shell is going to provide some concluding remarks. When he finishes, don't shoot off straight away. We have a networking reception afterwards. We also have a feedback form, which I would strongly encourage you to fill out. Should have found it on your seats, and that will provide us with valuable input to help us with the planning of future events. Alex.
So thank you, Simon, and thank you very much to our panel speakers who spoke so eloquently today. I hope you found this a useful input to the policy debate. Now, Shell, we like efficient regulation, we like efficient legislation, and we hope that the end result that will be adopted will meet that. The reason we like efficient regulation is because regulation drives behaviours, and it's behaviours that make a huge difference to performance, safety performance on the ground. And that's where our eyes are on, delivering that high safety performance. I'd like to just refer to an example of how behaviours, regulation can affect behaviours and how that can have positive or negative consequences. There was the question of environmental liability was touched upon, and we've heard calls for mutualised pooling of risk and mutual insurance products. Now, Shell, we believe that any spill that any operator makes, it shouldn't fall to the taxpayer, as was raised earlier. It shouldn't fall to the taxpayer to clean it up. But sometimes when you pool risk, it can lead to something called moral hazard, which is when the very existence of insurance can lead certain parties to be complacent. So we'd be quite worried if there was any move to ensure mandatory pooling of risk that led to that complacency. However, there are some ways where there are some policy ideas we have to give the assurance that society needs in a way that doesn't lead to that complacency. But to find out about that, you'll have to ask us over drinks. And with that, I will hand over to our moderator to open the drinks.
Thank you, Alex. Okay, very much. So, yeah, thanks. I'd like to very much thank you, our panellists, for a very stimulating exchange. Obviously, we haven't resolved many of these issues this evening, but the Parliament, the Council, the Commission and industry have been working very hard, so it's hardly surprising that we weren't able to settle it tonight. Thank you all very much for coming out on a Monday evening, and I hope you'll be able to join us for refreshments. Thanks.